Welcome. Welcome to A Taste of Justice. I'm Professor Angela May Kupenda. Now, this series is to support my students, to give them some supplemental information as they are taking my First Amendment course that I'm teaching remotely. But this is for all of us. Learning is on the path to enlightenment, freedom, and justice, or at least a taste of it. Now, I tell you that I'm a professor at Mississippi College School of Law. I've been teaching for about 30 years. But I tell you that only for informational purposes. All explanations here are my own, not to be ascribed to my school or my students. Now let's get right to it. In the last clip, we were talking about unprotected categories of speech. Remember, the general rule. The general rule is pure speech is protected from content regulation, and there are a lot of unlesses. One unless is unless the speech fits in an unprotected category, then the government may regulate it with a very low level of review, not with the exacting scrutiny that is required when government seeks to regulate pure speech for content purposes, pure speech for its content generally. Now, the court has held that not all speech is protected the same. The court has held that there are some categories of speech that have a low value, but a high risk of harm. We looked at that first category of unprotected speech in several videos. Speech that advocates illegal action. And now we're continuing to look at a second category of unprotected speech, and that is defamation. Now, in the prior clip, we talked about defamation and the case New York Times versus Sullivan, and I gave you some cites to some other cases and to the very interesting ad that was at issue in New York Times versus Sullivan. We came up with a rule. The court says the state has a right to protect reputations. But, there are a lot of buts, right? But it said, when we are engaged in debate about some matters involving public officials and their official conduct, or public figures who have placed themselves at the forefront, they've thrust themselves into certain controversies, then the court says we want the First Amendment to have some breathing room. And so even though the First Amendment is not there just to protect a lie, the court says sometimes a lie will happen in uninhibited, robust debate. So the court said, you look at whose reputation has allegedly been harmed. If it's a public official acting in their official conduct, or a public figure for all purposes, or a public figure a private person who's thrust themselves to the forefront of a controversy, become a public figure for some purposes. In those instances, even if a lie is published about them that harms their reputation, the court says they cannot recover unless they can show actual malice, that the lie or misrepresentation was made with knowledge that it was false or reckless disregard as to whether it was false or not. For the rest of us, private individuals and private matters, the court said the state can provide more protection for our reputations. It can have a standard like negligence or more fault. It's left up to the state, the standard, but it has to be based on fault, not just in accidental little misstatement. It has to be made with, you have to be able to show something like negligence or even more. But it's left up to each state as to whether they want to protect private individuals' reputations more or less. Now, for this clip, I said we were going to talk about defamatory-like speech that may not be, it may not meet the strict test of defamation, but it may inflict emotional distress. It may be the public disclosure of private information, may put the person in a very bad light. So those are the things we're going to consider today. I just decided to call it defamatory-like, but often it's called the public disclosure of private information. So let me give you a couple of scenarios for you to think about. I was looking at my notes, a couple of scenarios. Let's say that the speaker is a national magazine. And in this national magazine, they decide they're going to run like some political cartoons or parodies. And what they do is they do this clip, and they decide to pick on a minister, a very well-known minister, maybe some people would say a controversial minister. And the article is about individuals' first times sexually. And they run this clip in the magazine saying that this minister had his first time with his mother in an outhouse. So the minister files suit for saying that the magazine intentionally inflicted severe emotional distress on him, running something like that. So my question to you is, who do you think should prevail here? Should a magazine win? Oh, free speech. We were just funning. It was just a cartoon. We put a line at the bottom saying, don't believe it. It's a parody. It's just for fun. Or should the minister win with this is severe infliction of severe emotional distress? This speech has no value. The minister saying that he wanted to receive damages for his injury. Think about that one. Let me give you another one. What if there is a church, a well-known church, and this church believes that the country, the US, United States, is suffering because the United States, according to this church's views, the United States is far too lenient on issues of morality and is far too lenient in terms of giving, that the US gives too many rights and protections to LGBTQ individuals. So what this church does is whenever or often when there is a soldier a military soldier who is killed, whether the soldier is heterosexual or homosexual, it doesn't matter. What they do is they have a protest at the funeral, and they have some very inflammatory signs they post, and they protest the funeral. So this particular soldier, he's been killed in the military, and his father is having his funeral. And at the funeral, about 1,000 feet away, the father can see something going on over there, but he doesn't see exactly what. And so when he gets home, he sees the entire news report, and he sees what this church group was doing and what the signs were saying. And he is also grieving his son. It's the day of the funeral. And so he brings suit against the church for infliction of emotional distress. Who should win here? Should the father win because of the emotional distress he suffered as a result of this very severe protest at his son's funeral? Or should the church win? Should the church win because they said they had a right of free speech to engage in this protest? Excuse me 1 second. Okay. All right, let me give you one more. There is a law. There is a law saying in a particular state, saying that when there is reporting done about sexual assault or rape victims, the names should not be publicized. So that's the law. Well, a woman is raped, and the police complete an incident report about the attack. And a police officer inadvertently, accidentally leaves her name on the report. Now, and the report is accidentally left in the press room. Now, in the press room of the police department, there is a sign saying that the names of sexual assault, rape victims should not be printed in a paper. It should not be reported in a paper because of the Florida law and to protect their privacy. So, but here, the name is there on the incident report, which is left in the press room, along with a sign on the wall, and of course, a state law. So a reporter comes in looking at the incident reports to write a story, and the reporter is a female, she sees the victim's name. She sees the report, and she admits that she knew that she should not publish the woman's name, but she does. And after the name is published, the woman, her coworkers tell her about it. They see it in the newspaper. They tell her about what has been reported about her on her job. In addition, the rape victim, she starts to receive all kinds of threatening telephone calls from someone saying they were going to attack her again, and she is suffering severely as a result of the attack, and also as a result of the attack being made public, her name included. She had to move, change her phone number, all of this to get away from to try to get away from the threatening phone calls. Now, who should win there? Should the newspaper win because they say this is truthful information? Yes, there's a Florida law, but yes, we published it. We had a right to. Or should the victim of the assault win that the newspaper knew they should not report it, and now as a result, she has additional trauma, additional severe emotional distress? Now, these cases are all cases that I call defamation-like cases. So I want you to think about, where do you come down on these cases? Do you always come down in favor of free speech, regardless of the circumstances? Or do you always come down in favor of protecting the individuals who are spoken about from additional stress or trauma? Or does it just depend where you come down in terms of when speech is confronted by other interests? So let me tell you, and you can pause this for a while if you want to give some thought to those questions and decide where you come down. You can pause and then come back later and see if you agreed with the court. Okay? All right. You've paused. I'll go on for those who've already decided. Okay. The court, in all three instances, ruled in favor of the speaker. Okay, so let's go to the first situation involving the minister and a magazine talking about, making a parody about his first time. And let me point out that I'll give you, in the text below this video, I'm giving you the names and the dates of each of these US Supreme Court cases, so you can go back and read more for yourself. Remember, you can check my analysis of these cases. Learning is very important, and being a critical learner where you go and read things for yourself and sort it out is so important for our path toward justice. So let me go to the first case I told you about, involving the parody about a first time being with a mother in an outhouse. The name of the case is Hustler versus Falwell. And the minister that the parody was about is Reverend Jerry Falwell. Well, the court said that this was not defamation. Defamation is printing something that is false. And the court said that the magazine article clearly said this was a parody. This was like a political cartoon, not to be taken seriously. And the court said, additionally, Jerry Falwell is a public figure. And so if this was defamation, it would require a showing of malice. So here the court said it's going to require a similar kind of showing of actual malice in order to allow Jerry Falwell to recover for this parody. So in that case, the court ruled in favor of the speaker, in favor of Hustler magazine, and Reverend Falwell was not allowed to recover for infliction of emotional distress, because the court said, no, that would be an affront to the First Amendment. It was not a misrepresentation, because it was a joke, it was a parody, it was a political cartoon. And secondly, Reverend Falwell would have to show actual malice because he was a public figure. Now, what about the second case I told you about, involving the protest at the funeral of a military soldier. The case is Snyder versus Phelps. And again, the name of the case is at the bottom in the text and the date, a US Supreme Court case that you can read for yourself. When we cover this case in class, we always tend to have a lot of different viewpoints as to whether the court got it right. Now, in this case, there are 9 justices on the court. 8 ruled in favor of Westboro Church and the protest. Only 1 ruled in favor of the father of the military soldier. But the court kind of gave a hint as to some things a state can do to minimize these types of protests at funerals in the future. The court said, well, it was a protest. The Westboro Church was on public land. They were 1,000 feet away from the funeral itself. That the father did not really see the signs until they later on at home when he was watching it on television. But the court said, still, this is kind of problematic. But remember, we said that content-based, that pure speech is protected from content regulation, unless you can show a very high level of compelling governmental interest and a regulation is narrowly tailored to that interest. And the court didn't find that here. However, the court said that funerals are often very emotional times, and we do want people to be able to live and to bury their loved ones in peace. The court said this is what a state can do. The court said that a state can create a content neutral regulation, a reasonable time, place, and manner regulation that restricts protests at funerals, period, right? So it's not content-based, it's content neutral, the court would say, that set down requirements for how far away you must be, about sound, about this, about that, that could apply for any protest at a funeral. And as a matter of fact, that state had already, after this situation, created such a content neutral, reasonable time, place, and manner regulation to restrict other such protests. Now, one justice disagreed. One justice thought that the family, the father of the soldier, ought to be able to recover. One justice gave a very passionate dissent to the other 8 as to why this type of speech should not be protected. But you can Google that case and read more about it and see if you stand with the majority, with the 8 in favor of the speech, unless there's a content neutral, reasonable time, place, and manner regulation, or if you stand with the 1 who said, this is problematic. This is problematic, and the father should have been able to recover from Westboro Church. Now, what about the final hypothetical involving the woman who was raped, and then the reporter knew that the law said she could not publish the victim's name, but the paper was laying there, so she used it. and use the woman's name. And then the sexual assault victim, then she suffered severe emotional distress. Who should win there? Are you in favor of the newspaper and free speech in spite of the state law and consequences of this speech? Or are you in favor of the individual, BJF? Her initials are used in a Supreme Court opinion to give her some measure of protection for her privacy. Well, the court came down in favor of the newspaper. And I think the court's ruling would be very helpful. I'm going to read this to you. The court came down in favor of the speaker, BJF, the newspaper, reporter. BJF would get no recovery. But this is what the court said toward the end of its opinion. Our holding today is limited. We do not hold that truthful publication is automatically protected. We don't hold that there is no zone of personal privacy within which the state may protect an individual from intrusion by the press, or even that the state may never punish the publication of the name of a victim of a sexual offense. Wait a minute. So what is the majority saying? They're saying maybe in a different case, they would rule differently. Let me go further. The court said, we hold only that where a newspaper publishes truthful information, which it has lawfully obtained, punishment may lawfully be imposed, if at all, only when narrowly tailored to a state interest of the highest order, and that no such interest is satisfactorily served by imposing liability under this law, under the facts of this case. So they're saying maybe in another case. I mean, I put the language from this opinion down in the text so you can take a look at it. Now, this opinion, the ruling was, I believe it was 6 justices were in favor of the newspaper and 3 were in favor of recovery for BJF. Now, in some of these opinions, the language can tell you a lot. One of the justices who believed in protecting the speech, the newspaper, this is what he said. He called what happened to BJF, he called it discomfort. She suffered a discomfort. But then the 3 justices who dissented, they said this. Let me read their language. The line needs to be drawn higher on the hill in terms of how you draw the line to protect BJF's privacy and peace of mind in the wake of a horrible personal tragedy. So one justice, the one that ruled along with those protecting the newspaper, said BJF had discomfort, but the 3 who dissented said this was a horrible personal tragedy. And I think just that language may tell us a lot. What do you think? So here we have these cases, these 2 videos I posted, one on defamation and another on defamation-like cases for us to analyze, as defamation is another category, another unprotected category. But you know, there's some caveats in terms of how it is applied. For the next clip, we're going to the third category of unprotected speech, obscenity. Can you believe that? That I'm about to sit here and chat with you about obscenity? Well, subscribe and sign up for notifications. Learning is a key to enlightenment, and enlightenment to freedom, and freedom to justice, as promised under our Constitution, or at least a taste of justice. So sign up so you don't miss a thing. See you next time.